Time, I'll tell you, my name is Tina Lee. I'm the editor-in-chief of Unbias, the news, and we are hoping today to have a discussion about our latest story, which was called Exploitation Across Borders, a story about a group of Indian workers from Chennai who went to Kraljevo, Serbia to work on a large construction project, and when they were not paid or able to access other kinds of labor rights, found it very difficult to see which legal laws and regulations were supposed to apply in the situation, because they were Indian people, citizens, working in Serbia for an American company, working for a Chinese company. So it ended up being a very complicated set of labor regulations. And that's why we're hoping that we can get some clarification from our legal expert, Raavi Birbal, about what kind of laws apply when you go across borders. And now we're trying to bring Ravi on right now.
Want to tell us a little bit about yourself and what kind of work you do?
Well, I'm a lawyer. I practice in Supreme Court of India and High Court and various other courts. And I practice in various fields like employment laws, corporate law, arbitration, civil laws, and my super specialization is employment law. And I've had the privilege to appear for some of the best multinationals across the world and in India. That's what I do.
Perfect. So, I mean, the topics, employment law, multinational corporations, that's more or less the topic of the story. In the piece that we talked about, it involved a group of Indian laborers who were contracted from Chennai to work for an American company in Serbia. So what we found is that there was a maze of regulations and subcontractors involved in this, and this really diluted their ability to be able to access the law. So the first question I wanted to ask you is, why are Indian workers migrating to faraway places like Serbia?
Tina, my view is that there is nothing wrong with the law of India because of which people want to migrate outside, It's primarily to do with the poverty conditions. We've got massive population, large family sizes, uneven development, because of which people want to go out to richer nations and look out for employment opportunities. That's why people migrate to places like Serbia, even despite the tough conditions. And talking about the Indian labor laws, there is nothing lacking in Indian labor laws. In fact, Indian labor laws are some of the best in the entire world. They provide for every smallest detail of any human being. For example, with respect to minimum wages, you've got the Minimum Wages Act 1948 under the Indian legislature law. For payment of social security benefits, you've got the Employees Provident Fund Miscellaneous Provisions Act 1952. That takes care of employee social security at the time of his quitting of his employment. With respect to his medical, you've got Employee State Insurance Act 1948. That takes care of his medical benefits. With respect to an ex gratia severance pay at the time of quitting of service, you've got the Gratuity Act, that if somebody works for 5 years of service continuously, then he gets a gratuitous payment. Then if somebody works for 1 year in an organization, he is also entitled to bonus under the Payment of Bonus Act. These are the social security legislations that India has. With respect to their working conditions, governing their working hours, their overtime, their leave, their holidays, for that purpose, too, Indian legislature has framed many laws. For instance, if somebody is working in a shop or establishment, you've got Shops and Establishments Act. If somebody is working in a factory, you've got Factories Act 1948. If somebody is working in construction sector that you are really primarily concerned with, you've got Building and Other Construction Workers Act 1996. Then somebody is working in mine, you've got Mines Act. Somebody is working in plantation, you've got Plantation Act. There is no dearth of law. We have got flood of law. There is no dearth in Indian industries. We have got some of the best industries. Our product is best world over. Our raw materials are pure. We have got the best of natural resources. But why people migrate is lack of job opportunities. And primary reason for that is massive population. I am sure if we have more of foreign investors investing in India, we should be able to curtail this problem. Nothing wrong with the country or the legislations or the law. Wrong is our massive. But let me also add over here, while our population is our drawback, it is also a positive point. The glass is half empty, it's half full. Population is a drawback, so there is lack of employment opportunity. But we have got so many serving hands that if given the right opportunities, if given the right investors, we can actually serve the entire world.
Of course. Well, I mean, that's a good point that you bring up about population, because in our article, one of the things that was mentioned was that Serbia has a declining population. Part of that reason is because many people leave from Serbia to other countries in Europe to even work in fields like construction and things like that. So it's an interesting dynamic, because even though those jobs do exist in the country, foreign workers come in to take it and they go to other places. So
Absolutely.
I know in India, you may also have workers from foreign countries in India, and you also have migrant workers in India, which are when people also travel within the country, which is so substantial. What are the rights of migrant workers when they're in India? Are they able to access the exact same rights as Indian citizens would have, or do they have another set of rules that apply to them?
So if you're asking me for people who are, foreign nationals who are not having the Indian passport, there are two kind of conditions that exist for such kind of people. One are the working conditions, and second are the social security scheme. When it comes to the working conditions, like your working hours, your leave, your holidays, because you're physically present within the jurisdiction of India, you're working in the climatic conditions of India, the environment of India, the environment of the industries, you would definitely have the privilege of Indian labor laws like the Shops and Establishments Act with respect to the working hours, your overtime, your leave, your holidays. If you're working in a factory, you would definitely have the privilege of safety and health measures given under Factories Act. If you're working in the construction sector, definitely you would be protected by the Building and Other Construction Workers Act. If you're working in mine plantation, you would definitely get the protection of those acts. That's one part of the scenario. But the second is the monetary part, the social legislations part. Now in that, there's a very interesting thing which happened in the year 2008. Prior to 2008, there was no labor law which was talking about international workers. However, in October 2008, under the Employees Provident Fund Miscellaneous Provisions Act 1952, a proviso with respect to international workers was specifically added, which said if a foreign national not having an expat employee, an international worker coming from anywhere across the world to India, drawing whatever amount of salary, if it is running in several crores also, he would be entitled to Social Security Provident Fund benefit as per the Indian law, unless there is a social security agreement between India and that particular country. And this social security agreement is known as a totalization agreement. So like there is a totalization agreement between India, Denmark, India, Paris, India, France. If such totalization agreements are there, and the agreement says that employees would be entitled to benefit of that particular country, then they will not have dual benefit. They would have benefit of that particular country. But if there is no such totalization agreement, the employee concerned coming from outside, working within Indian jurisdiction, would have the benefit of Indian social security laws. Apart from Provident Fund, with respect to other severance benefit, like a severance pay, a gratuity, a golden handshake amount, that would really depend upon the contract of employment that the employee has with his employer. So whenever an employee is coming from outside, it's very important that he has a very well-defined contract. Now, with respect to this, is with respect to your social security benefits and with respect to your working conditions. With respect to other small things like minimum wages, medical insurance, people generally coming from outside India and working in India are having salaries far beyond the prescribed limit within these stores.
So, I mean, then bringing the question back a little bit to the migrant workers inside of India, so Indian citizens that go to other places. So we saw during the COVID crisis that there was mass migration, people going back from where they had been working before, and that there was not a lot of work employers that were taking care of them, either in the health sense or in the sense of helping them to return home when they had lost access to housing, access to employment. Are there new labor laws now that have been developed and that apply to these kind of situations?
You've asked the question just at the right time, because Indian legislature, Indian government is going to big change is going to be executed very soon. Our various labor laws are going to get codified into 4 codes known by the name of Industrial Relations Code, Organization Health and Safety Code, Social Security Code, and the Wages Code 2019 and 2020. Now, these codes, under India, what happens is whenever there is a new law to be passed, there's a bill which is introduced in the parliament, and the 2 houses of parliament, that is the Lok Sabha and the Rajya Sabha, they give assent to that bill, and thereafter it receives the president nod. Everything in the new code has taken place. Only thing remaining is that this new code is yet to be executed. So we already have a new labor code running into 4 codes in place, but it is only awaiting an official publication of the date of execution in the Gazette of the Indian government. The day we have that date published, the new labor laws are going to be in place. And what those labor laws are doing are as follows. They are making they're creating a balance between the employee rights and the employer rights. Till now, we have had some very, it's making less pragmatic, I would say. Like, for example, till now, what happens in India is that if there are workers working in a factory and you are supposed to retrench, you are supposed to terminate those workers. Then if they are working in a factory which has got 100 or more workers, you are required to take permission from the appropriate government before terminating those workers. Now, this number of 100 is being enlarged to 300. So, Tina, what used to happen till now is that while foreign investors were very happy to invest in India, sometimes they would feel that it's easy to open industry in India, but it's difficult to close it down. Now, this new law is going to change this number of 100 to 300, which would mean that if any factory has got 300 or less workers, it does not require permission from the appropriate government before retrenchment or before closure. So that's a big change which is going to happen.
Is whether or not the long waiting times for courts in India can affect people's access to justice in times like implementation of employment law.
Can you kindly just repeat your question? I think it's similar to what Ankita just asked.
Yeah, Ankita writes that in the story, the workers had to pay heavy penalties in Serbia for small things like being absent for just one day, and whether or not there are situations like that in India.
Yes, of course. There are situations like I just said right now while you were out. I said that, while there are no dearth of laws in India, but what we really lack, and not just in India, I would say across the world, we lack effective implementation of them. There shouldn't be, justice shouldn't just be done. It should be seen to be done. So what we really lack is effective execution of laws. And under the Indian laws, you've got provisions of civil consequences and of criminal consequences. Supposing you have not done compliance of a certain labor law, then you've got penalty to pay, and the directors or the senior officials or even the CEO of the company can be sent to jail. They can be in imprisonment. And after coming of this new code that I was just referring to, apart from various changes, these penalties that have been prescribed under the current laws, they have been enlarged. For instance, now for non-compliance, you've got fine of few thousands. Now it's going to be a couple of lakhs. And even the criminal prosecution of going to a jail for a couple of months, that's being made to a couple of years. So yes, penalties are being increased, but my personal suggestion to government, not just Indian but across the world, would be that I believe compliance of every worker, at least a layman worker, should be made website based, so that the worker and the government can track whatever compliances have been done by the respective companies.
That sounds like it would be a good setup.
Yes.
I want to ask, what other legal provisions and safeguards should be put into place to ensure that more workers can have the correct access to rights in India?
Yes. So I'll just this question I will answer with your previous question that you had asked. What changes are coming in the labor laws? So I was telling you that there is this provision of 100 under labor laws, which is being made to 300, that an industry before closing down does not need to take permission from appropriate government. Another safeguards and protections which are coming from the workers are as follows. India gives lots of importance to union movement. But till now, although Indian legislation had the intention of giving lots of importance to the union movement, there was no provision which said that managements are mandatorily required to recognize the union. However, now, as per the new code which is coming up, managements would be mandatorily required to recognize the majority union of the workers, which are going to take up the case of the workers with the management. then under Indian jurisdiction, you've got various kinds of employees functioning. Like you've got fixed term employees, you've got contractual employees, you've got casual workers, you've got regular workers. So till now, what used to happen is that you've got this Payment of Gratuity Act 19. Payment of Gratuity Act, under which after an employee completes 5 years of service, he's given an ex gratia payment, a gratuitous payment. So what used to happen till now is that Indian employers sometimes used to terminate the fixed term contractual employees before completion of 5 years so that they could save the money of gratuity. But under this new code, this period of 5 years for the fixed term employees is being changed to 1 year. This means that if you're a fixed term contractual employee and if you just work for 1 year's time, you would be entitled to gratuity, unlike a regular employee who's not much prone to termination, who gets gratuity on the completion of 5 years. Then apart from this, like I said, the penal consequences have been really enhanced. The penalties are going to be really harsh for any non-compliance of labor laws. And there is one more change which is now going to happen, which I feel is going to increase the productivity of Indian industries, and it's going to be good for bona fide workers also, those who want to work, would be that strikes and lockouts. Now there are going to be no urgent strikes or no flash ice strikes that we call as, because the new code says that before workers or unions wants to go on strike, they mandatorily have to give a notice to management. Likewise, if management wants to declare a lockout, it wants to close the industry, it doesn't want the workers to come inside, management can't do it overnight. It has to give a reasonable notice to the workers to ensure. Then another very interesting change, Tina, this is coming in the Contract Labor Regulation Abolition Act 1970. This act under Indian labor laws relates to the outsourced workers. So till now, what used to happen is that the contractor used to pay the salary, the middleman, the contractor, service provider, outside agency, as you understand, he used to provide the salary to workers, and there was no role. I mean, there was a role of principal employer, but there weren't many checks to see that the bona fide worker has received the money and the cash amount has not illegally gone into pockets of the middleman. So the new law which is coming, that across the country, makes it mandatory that the contract laborers payment would only be transferred by virtue of a bank transfer. There won't be any cash payments unless there are very special circumstances. It's a remote village area. There aren't any banks or there aren't any bank accounts and the person is totally illiterate. Then in such circumstance, the permission will have to be taken from the labor department and then you can make a cash payment. Otherwise, every payment of worker has to be mandatorily made to his bank account. So all this is happening, good things are happening, but yes, if website-based compliance is done, and if people are educated about their websites, how they can search themselves on website, I think we would be able to achieve a lot of compliance under the Indian labor laws and even abroad.
All right, I have two questions also from comments. First of all, you mentioned before that there were some really harsh penalties if employers don't comply with these. I wonder, is jail time also envisioned in this, like criminal penalties, or would it be fines?
Yes, it does. If there are non-compliances in Indian labor laws, jail penalty was always there, and now it's being made even more stricter. But practically, Tina, what happens is, there's a difference in what you write and what really happens. Jail penalties are there, but they are given in rarest of rare cases. Normally, you pay the fine and you're scot-free. You are not given jail penalty. But let me tell you, just when the notice of jail penalty comes, that creates a deterrent in the organization and an untoward situation, which is now because of which the jail penalty has been received, that normally is not repeated. So practically jail penalty may not really be executed, but that creates a good deterrent for the employers to take care that the laws are compliant.
The other question I have is from Ankita as well, which is that whether there are provisions for protecting workers if they face violations of their rights outside of the country. In the story that we mentioned or that we put out, one of the things that I found very interesting is that the Indian workers, they had immediately sort of taken some union-like activities. They went on strike. They even did a hunger strike. They did a sit-in. They did some peaceful, nonviolent activities to try to demonstrate for their wages. But they were told that their right to strike was not protected in Serbia. which is interesting because for Serbians, the right to strike is protected. For Indians, it is, but also for the company that owns it, America. So for all three countries that are kind of involved, there is a right. But the suggestion was that no, you're not in any country's legal territory right now. So that's what Ankita's asking, I guess, is whether Indian citizens outside of the country have these labor rights protected when they are working other places.
So, Tina, there are a couple of things in this. Whenever an Indian is sent out to work, there are proper contracts, there's a visa, and there is a specific permission which is required from the concerned department in India. And if there is violation of any of the laws, if the workers are not taken care of in the manner promised, then there can be a cancellation for that license. And I've personally done lots of cases like that, especially going to Middle East. You've got, people like chef or waiters going to Middle East. So if those laws, if their wages and their social security benefits are not protected, then there is a serious violation. The license get cancelled. You need to file a case. You need to apologize, pay a fine, penalty. And only if the government again reposes faith in you, would you be given license again. So, and talking about Serbia, like your story, I don't know if you're aware, Serbia has got a very well-defined law for foreign employees. It's known as the law of foreign employees, and they've got different provisions for people coming from Emirates, from people coming from European Union, and coming from different countries. In fact, the Serbian law also says that the employer of Serbia, even if he has not taken the license to get the worker, for some reason he gets the worker somehow, even then he would be obligated to pay him money. In fact, Serbia has got a rare law. It even says that the employer would be obligated to give residence to the employee that he gets from India or whatever part of the world. This is a very rare provision. Normally, countries don't have provision that the employer would be obligated to give residence. But Serbian law says that the employer would also be obligated to give residence. Apart from this, Serbian law also mandates the employer to take care of the insurance of the worker coming from outside. So, like I said earlier, there's a difference in having the laws and there's a difference in execution of it. The law is there, but the problem is awareness is not there. Whether they're doing
awareness is not there, but also in the case of Serbia and a lot of countries, I mean, I'm living in Germany, and Germany is not absent from this as well, but there are some instances where corruption can play a role in ensuring that legal rules are not enforced.
And I have something to say there, Tina. That's exactly my concern. That's what I've been fighting about. I've written a couple of articles on this and the court cases that I fight with. Corruption and non-performance. If we really need to improve economics across the world, then I think apart from, more investments, easy tax regime, what we really need across borders are faster disciplinary action. Moment you see somebody doing corruption or being indulging in non-performance or doing an unethical activity, I don't think that a lot of time gap should be given in taking a disciplinary and appropriate disciplinary action against the culprit. Once there'll be timely disciplinary actions, the actions are made time bound, economy is bound to boom. Procedures are bound to happen. So I think things should be made time bound, and actions, timely actions like disciplinary actions against corruption, against non-performance must be there.
Right, but we're seeing that that's a problem that's spreading all over the world. And in the three countries involved in this, and Serbia is an issue, but also in the United States, which used to be a country that was relatively well known for having a non-corrupt system. We've seen a number of cases in the last couple of years indicating forms of corruption and different forms of justice for more powerful people. And I think that this really hurts the ability to enforce the law, but it also stops people from thinking that it's worth it to bring cases to try anything, because they don't believe that it will be successful when they're up against powerful people. So it has a chilling effect on the enforcement of justice. What do you do when you have clients or you see clear violations and people are unwilling to bring the case forward because they don't believe it will work?
Can you kindly repeat that? I didn't hear it very clearly.
I wanted to ask, do you have situations ever where you would like to bring a case forward and the people that are involved don't feel confident that it would be worth it, or that it will take too long, be too expensive, or that they're not likely to access justice?
Yes, I mean, you do get to face these kind of problems every day. People do feel, in fact, whenever now a case comes to us, like, especially when it comes to a case like a property matter, or when it comes to things like a matrimonial matter. I mean, I personally, Tina, I always suggest to my clients that it's better you settle out of court. Think the settlement is not happening, only then go waste your time and money in court, because nothing is worth your life, nothing is worth your time. And in fact, India, in very interestingly, our Supreme Court, our High Court, and even our district courts, they are giving a lot of importance to mediation, settlement between the parties. Mediation, settlement of cases in India is really growing, and I am also personally in a lot of favor of it. Yes, there are people who come to us, they do feel it's not worth it. And even if they don't feel so, and if they are very litigant minded, they want to go and fight, I personally advise them, save your time, save your money, try and settle your disputes, unless it is something which is impacted, which is a dispute, or which is an offense of moral turpitude in nature, or unless it's a dispute of corruption. I normally suggest disputes of civil nature, matrimonial in nature, even labor in nature, one should try and settle out.
Well, this could also take some pressure off of the legal system, right? To kind of clear out the backlog and make some room for cases that are really important ones that have the ability to change precedent.
Tina, bad for lawyers, but good for the conscience. Good for the conscience.
That's right.
And I personally feel if you do right work, you get more work. If you do right thing, you get more work. The conscience is anytime more important. Yes, you're right though. This was on a lighter side. On a serious note, you're right. This would actually ease in the pressure of courts, and it has happened so in the past couple of years. And nothing like peace of mind, nothing. As lawyers, our duty is, of course, to see that the law is executed. Our duty is to see that the client succeeds. But our foremost duty is to see is that there is righteousness and there is peace of mind.
So we have another question, and then I think it's about time for us to start making closing remarks. But the question from Ankita is whether what has been the harshest punishment against a company that you've seen? And I'm also wondering, have companies ever been dissolved because of violations of workers' rights or gone bankrupt because of them?
Tina, this is a very important question, and it also is, I would say, it's I've seen so many. It's an emotional question for me because I have seen, if a wrong labor law advice is given, and that's why whenever we are advising the companies, we are very clear to tell them that before taking any major step, do seek legal advice. I have seen a wrong labor law advice, an advice which is given to sort of wrongly take away the right of workers or take malafide actions, for instance, of transferring people here and there, of terminating them overnight in mass, have actually landed company into liability of several crores. And yes, there are rare instances where due to major labor problems, union activity, wrong advices, companies have come to a closure. The work has halted. There have been massive strikes, major strikes, go slow, work stoppage, and ultimately losing of the case, which means giving amount to the workers with interest, penalty, and damages. But the worst thing that happens is the work gets halt. Things come to an halt. Factory stops. People go on strikes. Here, I would want to give a very interesting example of Japan. In Japan, what happened once was workers of a shoe factory, they wanted to go on a strike. But they were so conscience-minded towards their work. They were so dedicated towards their work that they said that, okay, fine, our intention is not to stop the work. We want to work, but our intention is that we should get our rights. So we will work. We will have the factory on, but we'll make shoe of one leg, left leg. We will not make shoe of the right leg. But this is not like India. In India, if mass actions are taken against workers, and if they are really annoyed with it, if the unions are militant, if the management is taking wrong actions, it is terminating people overnight, it is not giving them their rights, then those companies do not progress. That's really my experience in the last 18 years. And I do tell companies, if you want to progress, you must take the right advice, you must follow the law, you must take care of your work.
So actually, from both sides, it's important that the employees know what their rights are, but also from your view that the employers know, because it's not just in their interest as being a morally upright company, but also in their financial interests and their ultimate sustainability and success, that they're very attentive to all the different levels of employment law that they're subject to.
Absolutely, Tina. I have seen that companies who are liberal, who are flexible, who are good with their employees, good with their vendors, they do really well, they progress. But companies, those who are narrow-minded and they indulge in petty of, sort of cutting the salaries or taking the incorrect action, sooner or later, there has to be a big downfall. And, we say, like, this is something we advise, if your initial action is wrong, your ultimate result in the court case will also be wrong. So your initial action has to be as per law, even if you have to spend a little more money on that.
Well, let's see what happens. But in the case that we were talking about in Serbia, it's a bit sad because the person who started this company was the father of the woman who now owns it. And he had very good reputation when he died. The company had a very good reputation. And now, because of all these questions surrounding the treatment of the workers, the reputation of this family-owned business has been brought into a real question, and it looks like it may also cause them to dissolve at some point. We will have to wait and see what happens. But it's really true what you say, that not paying attention to the labor laws.
Exactly what I said. If you don't take the right step, and if you don't pay your people, if you don't take care of your people, if you're not following the law, of course your reputation has to go and there has to be a downfall.
Absolutely. And so it's not just a moral issue. It's really about whether or not you want to ruin your reputation and have one in the future.
Absolutely. People, your foreign investors, in fact, you've got Fortune 500 companies. People give you, in India, there are lots of Fortune 500 companies investing. So people want to give business, foreign investors want to give business to Indian companies that are, pro-employees and that are complete with their compliances. Let me tell you, I'm working for lots of foreign companies who have their businesses in India, and sometimes they tell us they would not want their court case to be shown in the cause list of the court or to come on the website of the court, because if the foreign counterpart looks at that case, then they may not, want to continue the entity in India or may not want to invest in India because they have very ethical values. So obviously, if you lose your reputation, you lose the investments and people lose trust in you.
Yeah, it's sort of a domino effect because it can lead to less foreign direct investment. And where a country has a good reputation of how they treat their workers, they can draw in additional ones, perhaps. Yeah. Well, thank you so much, Raavi Birbal, for having a discussion with us about all of these layers of protection that are on paper accessible. In some cases, people are also able to successfully bring these claims, and the sort of reasons why companies and employees should also pay attention to labor laws more specifically. We would have to close up now, but it was really nice talking to you, and wish you a nice and pleasant rest of your day and weekend in India. And we're signing off then from Berlin.
Thank you. It was a pleasure. Thank you.
Thank you very much. Bye, everyone.